Hey, ladies and gentlemen, this is Carmine Sabia for Explain America, and anti-Trumper and husband to Kellyanne Conway. George Conway, he just got taken down and taken to school by a CNN legal analyst. Before we get started, please make sure you like, comment, share, and subscribe. Those little things really help us out, and they help our channel continue to grow. So George Conway was on CNN yesterday when he tried to argue that Colorado was correct in removing Trump from the ballot because of the 14th Amendment. Now, Conway's original argument was that it was wrong to remove Trump from the ballot, but I guess after getting some pushback from his liberal friends now and liberal followers on social media, he decided better of it, and now he's strong support of Colorado because he's a grifter. That's what he does. He's trying to make money. He's trying to make himself more famous, and he's using Trump to do it. It's been that way since Trump was president. This guy has ridden Trump's coattails more than anybody. Elie Honig, a legal analyst who I cite here often because he calls balls and strikes. He's fair. He's on CNN, and he took George Conway down. He's against the Colorado decision. He thinks the Supreme Court's going to overturn the Colorado decision. And he took George Conway to law school yesterday. And I want you to watch this clip. But before you do, I want to ask you again to like, comment, share, and subscribe. I'm Carmine Sabia for Explain America. We love you guys. God bless you. Take care, everybody. Now let's watch this clip.
Yeah, I approach this whole issue with trepidation because it is a big deal to throw a former president off the ballot. But I was convinced very much by the original Law Review article written by the conservative law professors. I said, wow, this is a much stronger argument than I thought. But I still felt that courts were going to try to look for a way out, and that somehow, some genius legal lawyer or law professor would come out with a response. And when I saw the Colorado case, I didn't see one. I didn't see a federal argument against what the Colorado Supreme Court did. And all the arguments that I have seen against disqualification are bogus, like the one with, my friend Elie just mentioned. He suggests that the only way that Section 3 of the 14th Amendment could be enforced is through an act of Congress. That's just not true. There's nothing in Section 3 that says that. There's nothing that says that in the other provisions of the 14th Amendment. And if it were true, that would mean that if Congress repealed tomorrow all of the civil rights acts that were enacted from the time of the Civil War through the 60s to the present, that would mean under Section 1, which prohibits race discrimination, that would mean that the states could immediately start resegregating their schools and there would be no way to enforce it. That's just not the law. And there's nothing in the 14th Amendment that says that Section 3 is any different than Section 1 in that score. So that argument just goes out the door. All the other arguments that I've seen that have been raised, like the argument that the president is not an officer, is just, that one is silly because the Constitution refers to the presidency as an office dozens of times. So, really the arguments are pathetically weak, and unless somebody comes up with something better, the Supreme Court's going to have a very difficult time avoiding the consequence of the plain language of the 14th Amendment.
Elie?
I agree with original George here, where he started off. There is language on this specifically in the 14th Amendment. Everyone's talking about Section 3, which is very important. It says if an officer engages in insurrection or gives comfort to enemies of the country, he's disqualified. Great. But Section 5 is two sections ahead that says Congress shall have the power to pass legislation to enact this amendment. So has Congress done that? No, it doesn't say Congress shall have the power. Or states can if they feel
nonsense.
Like it. It says,
Elie, that's just complete nonsense.
It's the language of Section 5. I think we have Section 5. We'll call it up. What's your response to that? Section 5 is clear. It says Congress has the power.
What you just said, it does have the power, but it does not say, what it does not say is that the amendment is not self-executing. And that's the point I was making with Section 1, Elie. What it means is that if Section 3 says somebody who's engaged in an insurrection is not eligible if they've already taken an oath, then that's what it means. You don't need Congress to tell you to follow the Constitution, no more than you need Congress to tell you to follow the Section 1's prohibition in the 14th Amendment that says that you can't put black kids in a different school.
I'm not following
it's
that
just not that hard
whatsoever.
I don't know what you're talking about.
Congress shall have the power. This self-executing point.
Congress says that provision, Elie, you know better. You've read the provision. that provision applies to Section 1 as well. Your logic would mean that courts could, that states could engage in race discrimination tomorrow if all the civil rights statutes were gone. It's just nonsense, Elliot.
Not at all.
You know
That's not what it means. It says Congress shall have the power. You're trying to add
It's nonsense, Elliot. It's not an argument. It's not a serious argument, Elliot. I'm sorry. It's not a serious argument.
I mean, you're speaking in conclusory terms. You're not addressing the actual issue. Let me
I'm
make
not
this
speaking.
point about
You're
the
the one speaking in
self-executing point.
conclusory terms. Elliot, I made a complete argument that Section 3 is parallel to Section 1. That's what we do as lawyers. We don't say that a provision that's like Section 5 that says that Congress has the power. That does not mean that that a provision of the Constitution is not enforceable unless Congress says so. That's nonsense. Okay. If the framers of the 14th Amendment had meant to say that, they could have said that in words of one syllable. Instead, they said in Section 3 that somebody who engages in an oath to the Constitution, to support the Constitution, then engages in insurrection, which isn't really a hard requirement for somebody to meet, not engaging in insurrection, they're barred. And it says that without regard. It doesn't say unless Congress does something in Section 5. It doesn't say that. And I'm a conservative. I was a member of the Federal Society. This is how we read plain text. We don't make stuff up just because we don't like the result.
This is not textualism. This is pretzel logic. I agree with you. Let's take it as a given that Donald Trump... George, you have to let me talk at some point. George, come on. You're filibustering.
Okay.
Let's let Ellie make his point, and then I got a question for you, George.
Let's take it as a given that Donald Trump engaged in insurrection. The amendment itself is clear. You want to talk text? Section 5 is clear as can be. Congress has the power. What you're trying to do is read into it, and so do the states. Let me also make this...
You're misreading Section 5. The text says Congress has the power.
Put it up again.
It doesn't say that... Okay, it says Congress has the power. It doesn't say that Section 3 doesn't stand alone. It just doesn't.
George,
you're just,
you have to give me a second here, George.
Okay,
the self-executing point is when you keep going.
Ellie, you're just not making any sense.
Okay,
George, listen.
Can we?
I'm sorry.
For the viewers at home who are wondering, I mean, at the heart of this, and I think this is important, George, because what you were writing, what I referenced earlier, is that you formerly were skeptical of the idea that this is something that could bar Trump from the ballot. But what about the argument here that we've heard even from people who, and I should note that you are certainly not a fan of Donald Trump's, but what about the argument that for a court to make this decision, not the voters, that it's undemocratic, that they should make the decision of who's on the ballot instead of just simply the voters deciding who should be on the ballot for something of this matter?
That doesn't work either, because the provision we're talking about, Section 14A3, was approved by Congress and by the states. And there are other provisions in the Constitution, like the requirement that the president be 35 years old, that he be a natural born or she be a natural born citizen. Those too restrict the ability of people to vote for whoever they want. And the democratic way to overturn those requirements, including the requirement, which is, again, as I say, is a really easy one, don't engage in an insurrection, don't try to overthrow the government. The way to overturn that requirement or modify it is the democratic process of proposing and the Congress adopting and then the state legislatures approving another constitutional amendment that undoes Section 3 of the 14th Amendment, at least as far as it affects Trump. I don't know.